you are more than welcome to come and see me in the library.
I think I just set up recording, so now I'm recording.
Okay. Yeah, that's good. Oh, and it's Jim. Wonderful.
Sorry.
Jim, if you would need if you'd like a minute, I can start talking about PTRC. I'm going to start sharing. All right, so for my presentation, I have set up a little guide. You can find it there at that URL. There you'll find the slides for today's exercise that I'll be presenting, as well as some of the resources that I will be going through, links to different things from the USPTO that we'll be exploring, as well as links for the handouts for those of you who are remote and didn't get that physical copy. Or if you don't like paper, they're all there. So, like I said, I'm Annalie. And I'm going to do just a basic introduction to the PTRC, do some basics of patents, basics of patent searching, talk about trademarks and trademark searching. We'll take a little break. So how many of you are familiar with PTRCs? One, okay. So patent and trademark resource centers are formally designated by the USPTO. We are libraries that have been selected as places where the public can come and get information on patents and trademarks. So if you are affiliated with Michigan Tech, if you are unaffiliated with Michigan Tech, honestly, it doesn't really matter where you are geographically. I'm here to help you understand the USPTO ecosystem surrounding patents and trademarks. So,
Good question. He's asking what method we're referring to, so maybe I can share that.
oh, I did forget to share my screen. We are working in a hybrid online and in-person environment. So please excuse anything that is missed, and thank you for asking questions. Letting us know when we're missing stuff. So that link, again, for those of you who are remote, is right here. And if we could be able to put that in the chat, maybe. So PTRCs are located across the country to make it easier for people to join us physically across the United States. So the PTRC at Michigan Tech serves a pretty broad region, the entire UP and northern Wisconsin. There are a couple of other PTRCs in lower Michigan, but anyone is really welcome to contact any of them. We've been serving, PTRC representatives have been serving in our capacities for a variety of lengths of time. So there are people out there who have a lot more knowledge than me, and I have their knowledge at my fingertips for whatever questions you have to, if you don't feel like reaching out to unknown individuals. How many of you know how the USPTO is funded? Good guess, really good guess. In fact, that's probably what most people think. USPTO is actually completely funded through user fees. So when the government shuts down because budgets haven't been passed, USPTO keeps operating because it doesn't rely on that funding. When you look to get a patent or get a trademark, you are going to see all of those fees. The fees are very complex and they pile up. So getting a patent, getting a trademark can be very expensive, independently of hiring a lawyer. So definitely keep that all in mind as you're thinking about filing for this IP. Any questions?
Almost.
Okay. All right. Who here is familiar with the difference between patents and trademarks? It's okay if you're not. That's why we're here. One person, and she's a librarian. She doesn't care. Well, We have a picture here of a Coke bottle that actually represents a collision of both patents and trademarks. So that's a little confusing. A patent is an invention. So patent is granted for a thing. Now note that you cannot get a patent for an idea. It actually has to be a real thing that you thought through and created. These are things like plants. Yes, you can get a patent for a plant. We actually have paper plant patents on the second floor of the library, those next door. Designs and things like mechanical processes. Now a trademark is used to identify a product or a service with a recognizable mark. So something like a logo, a word, shape, color, smell, even a sound. So looking at this Coke bottle, what parts of it would you say are a patent and what parts of it would you say are a trademark? Any guesses? Yeah.
Trademark is the name, patent design, the actual liquid itself.
That is an excellent guess. So the trademark, you are correct, is on the way that the name is shaped on the bottle. So the spelling of Coca-Cola on that bottle is a registered trademark. Now the patent, you said an interesting thing. The liquid in the bottle is actually a trade secret. The bottle itself is a design patent, and we'll talk about design patents. That's a little tricky because when we talk about patents, we're usually talking about things like utility patents. And if you're interested in reading more about the collision between patents and trademarks, I have a little news article here that talks about the microgroup industry, how they are marketing their product by advertising the fact that they use patented hops, right? In addition to doing things like trademarking their logos. This might be a nice place for Jim to hop in. Would you like to get your slides up? All right. Stop our share for a moment. And there you go. All right, for you folks that are remote, Jim is going to hop in and share. Okay. Don't forget to share your guidance.
Yeah, I'm gonna. There. There we go. So, again, apologies, late. I did want to take, so Annalise is kind of getting into the, and she'll have a lot of great content around the details of patents, trademarks, on search, the tools that PTRC has. So as a little background, if Lisa may be a little redundant over what Lisa commented, but one of the things I do at the university is work in the Office of Research, and we work to commercialize technologies that come out of the research that is done on campus. That often involves developing an intellectual property strategy, but it is intellectual property as a business tool. The strategy is wrapped around it. I happen to have a license to practice patent law. I'm a member of the patent bar. I don't have a Juris Doctorate, and so the only law I can practice is patent law. I can't practice civil law. So the joke I tell about that is I can't get you out of a speeding ticket unless you have a speeding, an invention for getting out of speeding tickets. But I can only practice law in front of the U.S. I start with, so the title of the slide is intellectual property as a tool, and this image is actually chosen quite deliberately. So it is moving a business forward, moving a commercialization project forward, moving an innovation into practice. Sometimes you need to pull things with the pliers, sometimes you need to push things with the hammer, sometimes you need to stick things with the glue, sometimes you need to unstick things with the WD-40. So tools have specific purposes. And the hard hat represents the patents. The patents protect you from competition. They don't really do much else as a business tool than protect you from competition. You must execute on your business strategy and use the protection of the tool that is the patent, but also you have to use these other tools to be successful. 97% of US patents never make it to a profitable outcome, never make it to sales. A smaller percentage make it to profits. The patent in and of itself is not a destiny to financial or fame. It is a tool that you can use for that. So the process of moving towards adoption of an innovation, we think about it in the context of commercialization, but in the broader picture of encouraging the adoption of an innovation involves overcoming 3 levels of risk. Technical risk, and I won't read the slide, but in the interest of time, does the technology work? Does it work the way you think it does? That is step 1. You have a concept, now you have a proof of concept, and you have a prototype built in a way that an end user can use it. Business risk is really fundamentally who cares and are they willing to pay for it? Are there enough of them to sustain a financially viable solution? If the offering is going to be manufactured, for example, it has to at least break even on the manufacturing cost. So the solution must satisfy the business risk as well. So you have technical risk, doesn't work. Business risk can at least break even. Proprietary risk is really where intellectual property comes in. Do you have a means of creating and sustaining a distinctive competitive advantage? And have you developed and employed a diversified strategy for achieving this? It's not as simple as getting a patent. It's not as simple as getting a trademark. It takes a diversified strategy. So Annalise will cover the details. Copyright is a work of authorship fixed in a tangible medium. So it's not the idea, it's the expression of the idea. The trademark, she just went over the brand, the identity of the brand. Trade secret is a legally protectable form of intellectual property. Most, if not all, companies exercise some level of trade secrets in their activities, but it is legally protected. There are laws built around the protection, management, and enforcement of trade secrets. 3 types of patents: utility, design, and patent. That Annalise went over it just generally. So I always try to make my point about the relevance of invention and patents with the case study of who invented the light bulb. So who invented the light bulb? Everybody knows it's a trick question. Nobody wants to answer. This gentleman, Sir Humphrey Davy, was the person who first experienced incandescence. So he discovered incandescence. This gentleman, Frederick de Moyan, was the first to receive a patent to a design for an incandescent light bulb. This gentleman, Joseph Swan, was the first person to sell an incandescent light bulb in Europe and began in the early 1860s, I think. So who is this guy? And why do we know who this guy is? He did distributed power and centralized generation and distribution of power. So he addressed the business risk of the light bulb. He didn't invent the light bulb. He wasn't the first to patent a light bulb. He wasn't even the first to sell a light bulb, but is generally recognized as the person who invented the light bulb. So much so in terms of the technical collaboration between Edison and Joseph Swan, they formed a joint company, Edison Electric along the way. The relevance of Swan was real. He was part of the solution. So what did Edison do, or what happened in the technical risk timeline of light bulb? Years of development, numerous teams, lots of individuals. Edison came up with a filament that had a little less fragility or a little bit longer longevity. He also did some work on vacuums, and he did power. He did on the business risk side centralized power, but also a more economical to operate filament. He happened to have patents, but he also had branding for his company, trademarks, and an extensive listing of trade secrets. Some statistics around that, particularly, so execution, the title of this slide says execution was always of utmost importance, but now is more important than ever. There were a series of Supreme Court cases. This line is the allowance rate of US patents. It dropped precipitously in the early 2000s. It really hasn't come back. Patents are harder to get than they've ever been. there's good reason for that, and there's lots of good conversation around it. That's a healthy element of the patent system, but they're hard to get. The bar chart on the right is the invalidity rate of patents that go to trial. And the orange bar is patents that are the percentage of patents in that field that go to trial and are invalidated. You will see one of the bars goes across the whole thing. Every patent that went to trial in that year in that field was invalidated. So they're harder to get, they're harder to uphold. So execution is critically important. This is the process that we use to move an invention through to commercialization. I won't take the time to go into it. And then I will just advertise for some resources. Lisa's the program manager for Husky Innovate, lots of campus resources for moving innovations forward. And we can connect you with lots of other resources, including the local smartphone technology business incubator. So with that, I will turn it back over. And I will be available throughout for questions as they come up.
Thank you, Jim. All right, I'm gonna hop back on here. Left off with patents versus trademarks. Questions on that? Flip through. Okay, so what exactly is a patent? Well, it grants a patent holder certain rights in exchange for the public disclosure of an invention. So you are telling the world your invention works, but you're getting certain protections in exchange, which Jim talked about. Okay, changed our sound. Is this an issue, John? Getting a message on the screen. For
Good.
Looks like it's gone away. Just want to pause. If you have trouble hearing, Lisa is monitoring the chat, so just let us know. So when you have a patent, you can exclude others from producing, using, or selling the invention within the United States. You can exclude others from importing an invention into the US. So we're talking about United States patents here. Is there such a thing as a global patent? No, there is not a global patent. When you get a US patent, it is for the United States. You can get patents in other countries, and there are some agreements, the PCT, that make it easier to get patents in multiple countries. Before we go any further, is anyone here already familiar with the concept of prior art? Very important when we talk about invention. All right, so an invention is patentable if it is novel or unique when compared to prior art. And prior art is just everything that's out there. So anything that's publicly available. What do you think counts as prior art? Definitely other patents. Things like journal articles, conference presentations, anything that you can find that's available to the public counts as prior art. So with that concept in mind, let's actually look at a patent together. So this is available in the LibGuide. And if anyone who is attending remotely is having trouble accessing the LibGuide, just chat Lisa, we'll figure it out for you. So we have the anatomy of a patent document, right? And I actually printed off the patent set that discusses for you as well. So got one, or can access it remotely. Great. Thank you for bearing with me.
That they don't see your screen.
Here we go. Here we are. Okay, great. Let's start with the title of a patent. This one is for the Crocs shoe. The title is breathable footwear pieces. When we start searching for patents, we aren't going to want to use keywords, and this is a really good reason why. Because if we were looking for a Croc, would any of you have thought breathable footwear pieces would be a good set of keywords or key phrases to search with? I'm seeing a lot of shaking heads, so yeah, no. The inventor and the assignee are very important parts. The inventor is Scott Siemens, but who actually owns this patent? Crocs, right? The assignee owns the IP. The inventor is getting credit for it. The application date is going to be very important. We'll talk about that. We also have the patent number in that top corner. Each patent gets a unique number. There are some classification codes here. We will touch on classification codes and the importance of those. Not every, but many patents will have drawings associated with them. You see the drawing of the Croc there. References can be really important to check when you're doing patent research. The abstract is going to be a really good portion to look at if you are familiar with any technical jargon in the field that this patent is related to. And then we have specifications and claims on that, the second page here. So specifications are going to be pretty technical, and then the claims are going to outline legally what the patent does cover. Okay. So if you've never seen a patent, congratulations. Any questions on that before we move on? Okay. So why patent your invention? Jim brought up some really good points. You can deter others from a market. Right? You can assert or enforce those rights that you've been granted via that patent. Like I mentioned before, there is no global patent, so you cannot assert these rights worldwide. Only in the United States if you have a patent in the US or in the other countries where you have patented your invention. Right, so you can gain entry. Oh, we have a question from our in-person attendees.
So if you get a patent in the United States, but somebody manufactures it overseas and then sells it in the United States, can you try to,
Yes, you
collect
could
it from
then
them?
sue them.
Yeah.
The law would be on your side. You would be able to prove that this is your patent invention.
So if the transaction is then made in a country outside of the US, but then shipped into the US, would you still be covered? Could you still sue, or would it be a loophole?
I think the physical importation, and Jim might be able to talk to this, but the physical importation of that invention into the United States would be barred.
Yeah, so make, use, sell, offer for sale, or import to any manufacturer. Also, so there's a little bit of a detail around your question that if the transaction, all the parties are outside of the patented jurisdiction, but then it winds up in the patented jurisdiction. So you can sue the external, so you can sue the local party for use of the object. You can also sue the company that sent it to them for what's called contributory infringement. So they're not directly infringing because they're not doing any of the activities in the jurisdiction, but contributory infringement, they would be highly exposed under contributory infringement. So it does protect you.
So if you have a patent on something, you can market and promote the unique aspects of that product, right? Patentability means it's a novel and unique idea. You could use it as collateral to obtain funding. You know, this is your patent, nobody else can use it. So if you want research done, fund me. Or you can sell or license it like other property. So make a little money, not by using your invention, but by selling the rights. So we talked about 3 types of patents generally. Utility patents are probably the most common. You might not be able to see it. There we go. I learned last spring that we hit 11 million utility patents, so that is undoubtedly higher now. They are the most common type of patent. They are granted for machine, article, manufacture, process, composition of matter. So things like medicine, pharmaceuticals would be considered utility patents. So these are granted for 20 years from the filing date. And then of course you have all these fees that USPTO is going to pay. So there are a couple of links here for the photo picture here, the Great Plate. So I like to highlight this one because this person invented a plate, this couple, I believe it was, and nobody thought that he would be able to innovate on a plate. Now, how do you create something novel and new, unique when we're talking about something that people have been using to dine with for, I don't know, as long as humans have been around? But he did it, created something eventually that was unique. So this plate has a well in the middle that holds a drink. So when you're going through a buffet line, you can hold your silverware and your napkin, and also your food and your drink, and have 2 hands and not forget anything. It also floats. It also, flies through the air like a frisbee. So those are some of the unique aspects of it. Yes.
Would you like
question or
patent a different shape for a plate? I mean, you go out to different restaurants and they have like really fancy odd shaped plates. Are those patentable?
You
Or do they
have-
have to like have some functionality like this?
That is the perfect question. So a utility patent has to have some kind of use to it. So the novel aspect has to have some kind of new use. A design patent is something different. That would be ornamental. I'll skip this slide and go straight to design patents. Design patent is purely ornamental. So I think what you're getting at is something that just changes the shape but not the function. So then we would be getting into design. So when we talk about something like Batman's costume, that actually is a design patent. There's nothing about this part of his costume picture that is functional. He doesn't stab bad guys with his pointy ears. Those are merely ornamental. The Coke bottle that I mentioned earlier, that's a design patent. And then of course the Volkswagen Beetle, also a design, iconic design. So the appearance is protected, but not the function. And design patents are granted for 14 or 15, depending on the year, from the date of the patent was granted, not the filing date, like utility patents and plant patents. We'll get to. So Columbia Sportswear versus Wuxley, I think you say it, is an interesting case that was used recently. Columbia has this omni heat fabric that lines jackets that, it's kind of metallic, it keeps warm, but that's not the patent that they are suing Wuxley over. They have a design that goes on this fabric that, kind of markets how that's how they market this fabric. So Wuxley has recreated this design on the inside of their jackets, and they're selling them in Canada and elsewhere. So this is a Canadian company. They have online stores, that's available for folks to buy in the United States. And Columbia is suing them for this. And so many shoes. It seems like there are always shoe companies battling each other over design patents. And part of the aspect of some of these lawsuits is sometimes arguing over whether a patent is valid because the design patent is actually functional. You know, is this tie, this bow tie on the shoe, is that functional or is it ornamental? So there have been some interesting ones there. Plant patents. I mentioned that the library has a collection of plant patents on the second floor, right outside here. So these are the only patents that are still issued in paper because the color fidelity is so important. Color is a very important aspect of some of these patents when we talk about flowering plants. So these are granted for new asexually reproduced staple plants. And they are also issued for 20 years based on the filing date. So we have a couple of news articles here. Driscoll's, which is a company that sells fruits and berries, is currently suing somebody who has already been proven to be a strawberry thief. He is a plant researcher who used to work for UC Davis, and he and another researcher opened their own company selling these strawberry plants. UC Davis sued him saying, well, you stole all those strawberry plants and helped develop here. And the courts found that to be true. And now Driscoll's is piling on and saying, hey, some of those are ours. And it's up in the air whether or not that's a valid case. Yes,
Is
question.
it design patent also for 20 years?
A design patent is for 14 or 15 from the date the patent is granted. So different from the filing date, and we'll get into the importance of the filing date, I think. Next, yeah, what's with the filing date? What is with the filing date? Does anyone have an idea? Why are filing dates so important? Yeah,
because the process can take so long.
it can take a while, and that can work in, well, it depends. So in 2013, the United States kind of switched, well, really switched, became a first to file country. So filing early is beneficial to an inventor and getting ahead of other people while that process is going on of getting your patent granted. So the ownership of the patent is granted to you as of the date that you file that application, right? So it's retroactive if you are successful. Questions? Am I explaining that clearly?
So I guess how did it work before? So is first patent to get through the application process and be granted, then you're the first one, or how did the US do it?
So I think, Jim, do you know, was it like you had to prove that you thought of it?
It was first to invent.
Yeah,
Yeah, so we were the only country in the world that was first to invent. The rest of the world was first to file. In 2013, we went first to file because, and one of the reasons for that is the date upon which you invented something is inherently ambiguous. And so there were lengthy and expensive court battles over, that just, it just went on and on and on, and spent a lot of money. So we went to first to file because that's a definitive date. But it used to be first to invent. And if you could document, we were involved in a case, a first to invent case, and they were interesting, and you had to support your case, and the other side had to support their case. So there's lots of evidence that's brought, but it's a very painful process to document.
thanks. And this also kind of brings up, I didn't go into it, but it's just too juicy not to mention. So the day when you publicly disclose your invention is kind of the day you can claim it as your own, because then it becomes prior art to other inventors. So if you go to a conference and you say, hey, I have this great idea, this invention, and you haven't filed anything yet, you have a year from that date to file either a provisional or a non-provisional patent application. And you presenting that idea to the public kind of claims that as your invention. Correct, Jim?
Yes, in the
Yeah.
US.
Right. Right, which gets into a lot of things that would be great to talk about, but we might not have time today.
Was suffice to say, just in the US.
Yes. Question.
So if you present at a conference and someone listens to it and then they act on it, they can't do it because it's already prior art? And
In
you
the
can
United States.
demonstrate it's prior art because you attended the conference and you can demonstrate in a court that you registered and that you were there, and is that how it would, I guess?
And
play
there's
out?
probably a proceedings or maybe a recording of you doing that.
Yeah, if there's a public record, then it's simple, prior art, that patent will never issue. The other important piece of that is, first to file is actually first inventor to file. So only the inventor can apply for a patent. So I can't listen to your talk and then go file. Legally, I can't do that. I have to sign an oath and declaration when I file the patent application that says I am the original inventor of what I have. So you're committing fraud against federal government if you're patenting someone else's invention. So for two reasons, you have prior art on the record, so it would never issue anyway. And otherwise, it's the first inventor to file.
Yeah, another question.
So if it's a group that made the invention or collaborated to make the invention, how would that work? Would the group itself file as the inventor, or would it be a designated individual?
Multiple inventors.
Well, I'm sorry, I didn't hear that.
Multiple inventors.
Okay,
So
but each of the people, each of the persons has to contribute to the idea, right?
correct. So I don't know that this will mean a whole lot. It might mean a little bit after Annalise talks, but you have to have participated in the conception or reduction to practice of the claimed subject matter. So patents are defined by claims. What is invented is defined within the claims. And you have to either succeed or reduce to practice the invention as it is claimed. And it's a very technical analysis. We always use, so I have a license to practice patent law. We always use external counsel to do that analysis. It's very detailed analysis about what is.
Thanks. Okay, so we did talk about prior art already. I'll just go through these. Okay, so patent applications, yep, those are considered prior art. And this is regardless of whether your patent is granted or not, right? So if you talk at that conference about your great invention and you never act on it, that's prior art. If you file a patent application and it doesn't go anywhere, that's prior art. And patent applications will be made public eventually. They used to be kept secret, but that is not so anymore. They are searchable documents, just like patents. And there are a lot of different databases where you can look for patent application documents and granted patents. USPTO is what we'll be using today, one of their databases. The EPO will kind of get into a SPOTSnet a little bit. It looks like a SpaceNet, it's a SPOTSnet. And there are a ton of other patent databases that you can use. Make sure you never pay to use a patent database. You may want to pay someone to do patent searching for you, as long as they have the qualifications to do that, but never pay to use the database, right? Because these resources are freely available, and you're getting scammed if you're not paying, a patent lawyer. Like if you're paying money for something aside from something like patent lawyer, you might be getting scammed. Those scams are out there. Okay, so we will start patent searching next. Buckle up, everybody. Let's talk about why we're patent searching first. Anybody have any ideas why we would actually search for patents? Yes.
Prior art.
Yeah, we are going to be looking for prior art. And that's what comes up next. Yes, determine the patentability of your invention. Is my invention original or novel compared to the existing prior art? Patent documents obviously are prior art. You're also going to determine your freedom to operate. So you might not actually be looking to patent an invention. You might have, just a business idea that you want to run with, and you want to make sure you're not infringing on somebody else's patent. You don't want to get sued. Or make sure that they have expired. You might also be doing some data mining or market research. You just want to figure out what else is going on in a specific field that you're interested in. you might want to find partners, collaborators, or employers. So if you take a look at that Crocs patent that we looked at before, we have inventors listed, we have the assignee listed. Those are all folks that you could investigate further. Have even more. There's so many reasons why you might want to do some fact searching. Okay, so you might be doing some state-of-the-art searching. Right, these are primary resources, so they are quality, reputable documents. And customer discovery. You might be curious about a certain problem and you want to find existing solutions. So how are other companies, other folks addressing this problem? Are they successful in the marketplace? What are they doing in the marketplace with these apps? And who are the customers that are buying their products? Okay, so before you don't need to search for patents. And I mentioned keywords before. It's just an unreliable way to search. So I'm going to teach you some strategies for reliable searching in PAT-FT, so patent full text. This database is only available for full text search back to 1976 and then some back to 1971. So if you're doing any kind of keyword searching, you're probably only getting titles and abstracts of a lot of different things. Not all the patents are going to show up. Plus, we talked about the title of the Crocs patent, breathable footwear pieces. We've got smoke sensor, smoke detector. You know, you might be thinking of words that aren't actually used in the patent document. So it's not like Google, where there are smart algorithms that are connecting what you're saying with what you might actually be saying and bringing up all kinds of different sources. This is not that kind of database. What we're going to do is search using classification codes. So patents are organized by subject matter, and each subject is given a classification code. I'm going to teach you how to find an accurate classification code for inventions. So the CPC was developed, it's the Collaborative Patent Classification System. It was developed between the USPTO and the EPO. Prior to this, the US was using the USPC, and that's what you'll see on the Crocs patent. When you look at the classification section, you'll see that it says USPC. We're now using CPC. The patent documents themselves will never change. The database entry will be updated. So CPC has now been applied to all utility patents, and CPC is a living classification system. So as technology advances, these CPC codes change, and the database will be updated in accordance with those changes. But the patent document will never change. Okay, so to get you familiar with PAT-FT, I'm going to open PAT-FT. Hopefully everyone remotely is following along. If you get lost on the screen, let Lisa know. I apologize in advance. So PAT-FT, and go to pat-ft.uspto.gov. Follow along on your device if you would like, or just watch. We're going to go to the quick search. So it's a very simple interface. Doesn't look very sophisticated. It's just a government database that we'll be searching. So we have our Crocs patent. We have the patent number at the top. I'll show you how to search by patent number in PAT-FT. We got 6993858. Scroll down here. Oh, I think I missed patent number. There we go. It's right at the top. And we search. So because I had the exact patent number, which is unique to each patent, it brought up the database entry immediately for me. If you're searching by CPC or something that will generate multiple hits, you'll get a clickable list. You'll see that eventually. So database entry here. We've got all of the information affiliated with this patent listed on this HTML page. You want to see the document itself, you can see that by clicking images. And this brings up just the first page of the patent. You see all of the pages, the full pages. And this is a PDF that you can scroll through. You see this is the patent document that we were looking to further. Questions?
So the patent document itself is static.
Correct.
And what happens when an inventor comes up with updates to their invention? Is that kind of like attached as an appendix, or is it a completely new submission, different patent?
That is a brand new patent, and it will be listed on this patent document. You can see here. Ooh, this might be the first one. There's a separate section that lists, I think, previous patents. It's not on this one, but you should see references cited. You know, the previous patents will be referenced in the patent document itself. Welcome. My mouse here, sorry, attendees. Okay. I will just point out the CPC here. So you see it says current CPC class. These are all the classifications that will be updated as CPC is updated. So this is how this patent is classified currently according to classification scheme we use now. Okay, so with all of that in mind, we are going to move to a 6.5-step search strategy for looking at CPC codes and using those to search for patents. So the 6.5-step search strategy is in that guide, if anyone wants to download it, but we'll walk through it here. So also linked here. So step 7 is 6.5 because it's kind of an extra step tacked on. Questions before we start? All right, so you can think of this, each step is really pretty small. You can kind of lump them into larger steps. So we're just brainstorming a lot of keywords. This is where you get all the keywords out of your system. We use those keywords to find the relevant codes. We use the codes to find relevant patents, and then we go from there to find other relevant patents. So here is a scenario. We've invented a device that will attach to a fishing reel and display how much line is paid out. Anything like this already patented. We want to make sure that our patent is novel, or our invention is novel and unique, otherwise it won't be patentable. Spending a lot of money for no reason. Okay, so words that describe your invention. What does it do? We call out some words or type them in the chat. What does it do?
Measure.
It measures. Yeah. It measures. And the result?
Displays, right?
Displays a measurement. It measures, it displays a measurement. And think about what it's made of. Sometimes the composition of matter, if that's neat, that's patentable. So what do you think fishing reel attachment is? Have some plastic. Okay. And then of course, Is there any other alternate terms you can think of? So here's what I came up with. Alternate description. Display. You know, you can use the words that have already been used in the scenario as well. Maybe it's rotating, it's a housing, it's plastic, metal, meter, indicator. All right. So we are going to take some of these and search in a topic. So worldwide.isphosnet.com. Classification search here. Isphosnet has a really nice interface for navigating through and searching for CPC codes. The USPTO webpage also does, but I don't like it. It's newer. I feel like it's still a little buggy. It's not as user friendly. I just really like Isphosnet, so we're going to use this. And as you can see, CPC is organized by a few overarching categories here. So if you had to guess, which main category would our invention fall under? There are no wrong answers.
Can't read it.
A little small.
Yeah.
All right, we've got human
Maybe you can just
necessity,
read it.
performing operations, transporting, chemistry, textiles and paper, fixed construction, mechanical engineering, lighting, heating, weapons, blasting, physics, electricity, and general tagging of new technological development.
That one.
Maybe the last one.
So we'll put in some of our keywords here. Fishing. Not sure how keyboard works. Moment. Oh, there we go. There's just a lag. Sorry for all of you attending remotely and in person. The keyboard lags behind. We are fishing, measure, make real attachment. 0. Okay, let's try a few. Okay. So it looks like our results here, the highest recommendation is under fishing. Accessories, rods, reels, we've got some lines. That first category of human necessities in A. For the sake of time, I do have one classification filter down, and we're going to roll with it. Fine. All right, so you click one of these headings, it'll bring up further divided headings, and if you scroll down, you see here, line length or depth measuring devices. Sounds pretty accurate, right? I'm going to copy this, and we are going to put it into PAT-FT and search for patents in PAT-FT. Got some mouse lag here. Apologies for that. Oops, still on. Yeah. 801K 91/. And we are searching by current CPC classification. So we have 54 US patents that are using that classification code. Do you think maybe there's something here that sounds a little bit like our invention? Thinking maybe line length measuring device for fishing reel. Sounds pretty similar. All right, let's read the abstract. Folks attending in person, it's a little hard to. Oh yeah, line length measuring device for fishing. Sorry. Really hard to navigate this. Alive. Okay. So really wanted to know, check out this abstract, maybe look at the image here. And then of course, the inventors, the other current classification codes are ways that you can investigate other inventions related to this.
Quick question.
Yeah,
If you invented a device that did the same thing
Mhm.
that was already patented, could you still patent it because it's a different mechanism or different device?
some part of it would have to be unique. So you could accomplish the same thing with different means. Correct, right, Jen? Yeah,
The invention is what it is, how it does what it does, not what it does.
right.
So you can have multiple, like the light bulb, there's hundreds of patents to incandescent bulbs.
Okay, okay.
Filament design, ways to hold the vacuum.
Mhm.
Yeah, and Annalise made the point earlier, you can't patent an idea. So you can't patent measuring line coming out of a fishing reel. You can patent a specific mechanism
Right.
that measures line in a very specific way.
Okay,
And you yourself can have multiple of those inventions, but of course, others can have those inventions as well.
right. I mean, the car is the same idea. You can patent a different car, but it's basically performing the same function, getting you around.
Exactly.
Is it like a paper review that will be reviewed by someone to see if it's something will go through a patent just like paper?
Patents are examined. Yeah, the process of examination takes actually several years. They review for novelty and obviousness in light of the prior art. The challenge is, as the field gets mature, it gets harder and harder because there's more prior art. And you have to work harder to distinguish from the prior art. But as long as you can distinguish from the prior art, you can get another patent. And you may or may not have the right to practice that. May not be able to do it if you overlap a prior patent. You don't have freedom to operate to infringe that prior patent. If you invent it, doesn't mean you can do it if there's a patent behind you that covers what you're doing, but you could get that patent.
Thanks, Jim. And great question. Yes. There will be an examiner for every patent, and these folks are experts in their field. So if you are working in a very specific field, some folks get the same examiner more than once. All right, let's go back to our slides here. I think we did just about every step with that demonstration. Yep. So what else might you look at if you were trying to determine if your invention of this fishing reel attachment was novel or unique? What else might you look at besides that?
What's on the market?
Yeah, yeah. And Google is an appropriate answer here. If you want to find out what's in the marketplace, you can check out everything online. Patent application documents, you know, if you're looking in a particular field, what are professional organizations in that field? You know, we talked about conferences, journal articles before, that kind of thing. So the academic or non-academic. And we are now going to take a short break. Any questions before we do that? I think we might be kind of on time, according to the, yeah. scheduled, yeah.
So the prevent to practice.
Yeah. We'll try to keep it to 5 minutes, but you know, we need more time. That's all.
Are the slides available afterwards, or do we just come see you for that?
I can absolutely send you the slides. They are available on that guide I mentioned, which is publicly available. And actually, while we're all waiting, I will put that first slide. Holy moly. Not much. Okay. So if you want to go to this website here, the slides are available there, as well as the handouts and everything that we've gone through. But if you want to stop by my office, I would be happy to give you everything in a paper copy or electronically, or email them to you. And that
I'll
goes the
write
same
I'll
for
write
anyone.
this down. I'll write this down.
Sure.
And I forwarded the email too.
You can forward it to me?
Yeah.
Oh, awesome.
I can forward it to everyone.
Thank you.
Yeah. Going to mute briefly for everyone who's remote while we are on our break. Okay, we're gonna get started here for everyone who's back. We'll start with some basics on trademarks and then get into searching. So we mentioned before, a trademark can be like a logo. Be any word, slogan, name, symbol, design, combination, smell, color, sound, a lot of non-traditional marks, used to identify and distinguish goods or services and to indicate their source. So we have a few examples here. Starbucks, of course, very iconic. We have the new Michigan Tech Sports logo, well, maybe not so new anymore. I was here when they unveiled. And Marvel. Marvel and Starbucks, you can see that circle R is a registered trademark. And we'll get into what that means. Here I have a couple of links that lead to sources about trademarking colors. So, colors. Can anyone name an iconic color that might be trademarked? It's possible.
Navy blue, I think.
You know, it might be. That would be interesting to look up. Once you learn some search strategies, I encourage you to take a gander. But yeah, the Navy's logo, I mean, we can look at it, but for sure, the UPS brown is trademarked.
What about the maze, from like maze and blue for?
Oh yeah, you're talking to
You
a
know,
Wolverine.
yeah, I know,
I'm
yeah,
sure.
yeah.
I'm sure the blue and navy blue is trademarked. There might be some color claims on the Michigan Tech logo. So color is an aspect of that, but I don't know if Michigan. Well, now that I think of it, I don't know if maize is actually trademarked. It might not be like the USPS brown or Tiffany blue. Tiffany has that. The jewelry company has that blue color trademarked. What other colors? If you want to learn more, click the link. Non-conventional trademarks like sound, the NBC logo. Hear that? That chime with the unfurling peacock?
Can you do it for us?
Oh gosh, no. Look it up. But yes,
I have a quick question. Sometimes do they put TM as trademark? Are they different from R?
so the registered symbol is different. It means that you have a registered trademark. So trademarks, TM, service marks, SM, distinguish between the two, but doesn't necessarily mean you're registered. So when we talk about trademarks as a whole, what we're talking about is goods, tangible, things like services, which are intangible. So I mentioned that USPS Brown, Coca-Cola has a trademark. We talked about that before. Delta, it's a service. H&R Block, also a service. Post-it. Huh. So there's an interesting type of trademark protection called common law protection. This is protection derived from use. So if you have a company and you have a logo, you don't have to trademark that logo necessarily. You can use your logo. If you continue to use it, you have some protection under the law. You can prove that this is the logo that you've already used. If somebody else starts using that logo, you know, your next door business neighbor starts using something very similar, there's a possibility that you could successfully sue them. But having a registered trademark on the state or federal level means that the law has recognized that this is your trademark. With under common law protection, you need to prove that. So I mentioned state and federal registration. You register a trademark on the state level. This is for business conducted entirely within the state. Right? Federal registration is interstate, all over the country, governed by the Lanham Act. So state registration is typically going to be processed by the Secretary of State. Michigan has a system called LARA, which we won't talk about today, but it's good to know that that exists. Also good to know, the USPTO does not review state registrations when they register federal trademarks. So if you have a trademark that is registered on the state level, and you're, registered in Michigan, you're operating your business in Michigan, you don't currently have any plans to expand or do any online sales to other places, and another company comes along and they register a trademark very similar to yours, selling similar things, they could get federally registered, and then you would be limited to operating only in Michigan, right? So it doesn't necessarily mean that you have to stop using yours, but you couldn't grow your business to do a federal registration, for example. Yes.
Is there a difference between the costs of getting state or federal registrations?
I'm not sure about state registration, but I did write down some things on federal registration, because I do get that question whenever I don't put it in. And the fees actually just went up. I don't know where I put it. Right here. So you have the option when you register a trademark, and I wasn't going to talk about registration, but I think it's valuable to know what kind of fees you're dealing with. When you register a federal trademark, you can either do a lot of work upfront for the USPTO and put more information in your applications, or you can do less. If you do more, you're going to be paying less because you're doing more work. So that is known as T+, and that's $250 per class. And we'll talk about what class. If you don't want to do that extra work, it's $350 per class. And class kind of refers to like the types of goods and services you're selling. So if you're doing many different types of business, you could have many different classes. If you mess up your application and you miss things, you're going to be charged $125 per class for the stuff you're missing. So these are the kinds of fees we're dealing with when we talk about federal registration. I believe it's cheaper on the state level, but then again, you're not getting that same amount of protection. Any other questions? Good one. Yeah.
Like sort of related, I know that there's programs to help like low income inventors and stuff get patents. Can you help anybody find those programs or find the access to those programs?
Yes, I actually have a nice list of resources at the end of Trademarks that can connect you with some trademark groups that have a lot of great advice. I can help you navigate the USPTO website to find where they kind of advertise these kinds of things. I believe there's a pro se group. We'll touch on that when we get to the end on that slide for sure. Okay, so benefits of federal trademark registration. Why would you want federal over state? So you get to use that R symbol, right? Only folks that register their trademark with the federal government use the R. And your mark is going to appear in the test database, which we'll be searching in a little bit, which is great because then it's known, you're telling the public, this is my mark, and there's, no question about it. You have the right to bring suit against infringers in federal court and recover some sweet attorney's fees and damages from your infringer. Again, prevention of imported goods bearing this infringing mark can also serve as a way to get your product trademark easier in other countries. So there is this thing called the supplemental register. So if you go to register your trademark and it is denied because it is seen as clearly descriptive, which we'll get into, or merely descriptive, you may have the option to settle for being on the supplemental register. So these aren't trademarks yet. There's a chance they can become trademarks if the public starts recognizing them as connecting your good or service with the company. But there are some advantages. So you can still use that R symbol, which is pretty cool. Your mark will also appear in the test database, and it can make getting a trademark easier in other countries. There are some things called common grounds of refusal, the reasons why your trademark might be denied registration. So under law, the Lanham Act, no trademark shall be refused registration on the principal register as opposed to the supplemental register, unless there's something like a likelihood of confusion with another mark. Where do you think the confusion is? Who's confused here? Who would be confused? Yeah.
Consumer.
Exactly. We have to decide if the public would be confused, right? So it's not the person with the trademark. It's not necessarily, well, just the public, the consumer, and that's a good question to ask. So if the mark is merely descriptive, it could be refused. We'll talk about all of these a little bit more in depth. So if your mark is just geographically descriptive or geographically misdescriptive, deceptively misdescriptive, ooh, I always mess that up one. Geographically, deceptively misdescriptive. The mark is a surname, or you could have a specimen refusal. So, for example, if you don't submit a specimen, which is an important part of your trademark application. Question?
Yeah, so the mark is a surname, so like Ford is a surname, correct? So how does that work?
So, a great question.
I mean, I can imagine Ford would be like maybe before trademark, before it was trademark, or it's just,
Right.
the common name of the company, but
Yeah, and I paused because I wonder if at some point Ford was able to be on the supplemental register and make it onto the principal register, but I don't know if a surname can do that. I'm not sure if you know, Jim.
So I'm not sure about surname, but I suspect what happened is if you, it's called a famous mark, which achieves a secondary meaning. And so if the world associates that word with your brand, that's secondary meaning, and you're automatically trying to trademark for something. So I would speculate that they were able to achieve secondary meaning and then were able to register the name as a result of having achieved that secondary meaning. And there probably was some litigation before the registration under common law. That's my guess, but you certainly, they certainly did establish secondary meaning in the name. And so it has something to do with that path. If you establish secondary meaning for your mark, you have all sorts of privileges to earn that. And that's kind of the principle of trademark is you earn the brand recognition. You get a trademark if you use something in commerce. You can't get a trademark if you don't use it in commerce, and you earn more breadth of rights as the brand becomes more well known.
Thanks, Jim.
Thank you.
And the great thing about trademarks is you can look up all these trademarks and find them and view all of the documents that led up to getting this trademark approved. So you can see the whole history. If you can trace back some of the first trademarks that were sought, you can go and investigate that history, which I think is just super cool, and it's why I love trademarks so much. So moving on. Move on. There we go. The likelihood of confusion. We touched on this. Would customers, consumers, the general public be likely to mistakenly believe that goods or services come from the same company? So attorneys will compare trademarks using SAM and SUM. So are these marks similar in sound, appearance, and meaning, or similar in nature, use, and marketing? So we have a couple of examples here. Seikos and Seiko for watches, Coca-Cola and Coca-Cola for beverages, Esso and Esso, petroleum products, Toro Rojo and Red Bull. You know, even though it's Spanish and English, these were still confusing. Oral Angle and Oral B, similar enough. So these were all denied because there was a likelihood of confusion, and these marks are all operating within the same marketplace. They have the same products or services. So here are a few cases that have happened relatively recently. I really like this zombie Cinderella versus Walt Disney's Cinderella because I love zombies, but also because it illustrates that ultimately the Cinderella that Disney is referring to can't really be owned by anyone. It's at this point too generic. So Zombie Cinderella was denied a trademark, but then TTAB, the Trademark Trial and Appeal Board, which here's these cases, reversed its decision when Zombie Cinderella went back and contested that. So TTAB reversed and said, okay, Zombie Cinderella, you can have your trademark. It's not actually going to confuse the public. Walt Disney's Cinderella and Zombie Cinderella, those first words before the concept of Cinderella distinguish these marks enough. Jaws Devour Your Hunger versus Jaws. TTAB decided that the online cooking show, Jaws Devour Your Hunger, was infringing on Jaws because they were both in the entertainment industry, right? So cooking show and a movie, you might think that's different enough, but Jaws Devour Your Hunger is kind of referencing how famous the Jaws movie is, how ubiquitous it is in its very title, and they're in a similar enough place. Another common ground for refusal is that a mark is merely descriptive or generic. And you might not be able to see this very well, so I'll kind of walk you through it for those of you that are attending in person. So on the blue side, we have marks that are non-distinctive. And on the green side, we have marks that are distinctive. So your mark may be eligible for the supplemental register, even if it is found to be non-distinctive. But in order to make it on the principal register, you have to be distinct. So non-distinctive, generic, or descriptive, we have things like apple for apples. But you're going to be distinct if you're using the word apple for something like computers, something completely unrelated, right? So Apple, trademark. Questions about that? If you have a trademark and you're like, well, maybe I can get it to the supplemental register, you always apply to the principal register. You don't apply to the supplemental, you amend your application. A trademark can become distinct in the eyes of the public, probably something like Ford you mentioned. A trademark can also become generic. So things like Kleenex, right? We refer to Kleenex. Kleenex doesn't want you to call it Kleenex. They want you to call it tissue. They become too generic. They could lose their distinctiveness. Velcro came out with a really funny series of songs on YouTube with lawyers singing and dancing about how you need to call it hook and loop and not Velcro because we're going to lose our IP. So if you get a trademark, you can also use the other way. Which companies do not want to do. Geographically descriptive and geographically deceptively misdescriptive. So you can't just name your product after the place you are or a place you aren't. Surnames, you also can't just call your product Annalise Doll. I can't do that. Obviously, Ford was successful. But generally, a surname isn't going to cut it. My name isn't associating those words with a product or service that the public is going to recognize. Specimen refusal. So a specimen is an image of your product or service in action. And we can take a look at this in the text database. You have to submit this image with your application or as an intent to use. And within 3 years, you have to submit this specimen after you have been granted your treatment. So your specimen, it seems pretty straightforward. It has to be a real example of how you currently use your trademark in commerce. How it's used with the goods or services actually listed in your application. It has to depict the same trademark as shown in your drawing. So submit a drawing with your trademark application as well. It has to show your use of your trademark, not somebody else's. An appropriate specimen for goods or services, right? So if you are selling t-shirts, you can't have this trademark being used in a clothing delivery service. Show your trademark used in a way that consumers would perceive it as a source indicator for the good or services in your application. So it has to actually function as a mark. And the word function, I have linked to an interesting page, well, I think it's interesting, that talks about how when COVID first hit, a lot of companies were just slapping COVID slogans on t-shirts and calling them trademarks. Well, no, it's just a t-shirt slogan. This isn't actually marketing or branding your company in any way. It's not functioning as a trademark. And then of course, the T submission requirements. This link here has a lot of great information from the USPTO about specimen refusals. All right. 637, we're starting trademark searching. Perfect. Okay, let's talk about why we're searching trademarks. Why is it a good idea to search for trademarks? Why would somebody be interested in searching for trademarks? It's probably comforting. It looks really nice outside. Why are we searching for trademarks?
So that we don't get sued.
Yes, so to ensure that your mark isn't infringing on an existing mark. Also, historical brand research. I'm actually legitimately interested to learn the story of Ford's branding history. Because it's fun. You might be a nerd like me. Note, I didn't put that for patents. Patents are hard. Trademarks are also really difficult too, but I find it really satisfying when you put in a search and you find what you need. For some reason that doesn't work that way, but I don't know. So when you search for trademarks, you search in the test database using fields. So all the information that you see in a trademark entry in the database is a separate, distinct field. So here are just a couple. And you have the handout with the table at the end. You may have found it in the paper clip. I don't know if I have me. You'll see those in the table. So the basic index searches the word mark and pseudo mark. And a pseudo mark is words that other people may use when they mean the actual word that you use in your logo. International class. These are the 45 numbered goods and services categories that you get to pick from when you register your trademark, right? So you pay a certain fee for each of these classes when you register. Design search code. So much like patents, if you have some kind of visual mark, logo, you will get a number that categorizes that according to a certain subject. So we'll go through the design search code manual too. It's easier than translation index. So if your word mark is in a different language, there, translated to English, a description of that. This is where you can get crazy with keywords if you really want to. But just make sure you have a field, the field after it. I'll show you that stuff. Okay, so there are more fields. There is so much more information about searching trademarks. Everything I'm going to tell you is listed in the test help menu. Test help is going to be your best friend when you search for trademarks. I think it's really very straightforward. Not really very user friendly, but it's great. So we're going to do a little activity where we search for Michigan Technological University in the test database using this search option. So I'm going to navigate to test. We want to open this search option. And without telling you much about this search, I'm just going to see how it works. All right, so these are all of the trademarks that are owned by Michigan Technological University. And they're generally in order from newest to oldest. So this is the most recent trademark that Michigan Tech registered for, Husky Innovate. So we see here, it is just a word mark. There are several. Looks like it's just one international class, so one group of goods and services. Standard character mark, service mark on the principal register, and it's alive. What do we think alive means?
Inactive use.
Inactive use, yes. If a trademark is old and inactive, it's called dead. So trademarks are either live or they're dead. See the owner here, Michigan Technological University. Question.
How does it take to expire? Or do you do review it every year?
I think I have that written down. I knew I was going to get that question. Okay, so after you register your trademark successfully, you will need every 5 years, but it's good for forever. Maybe it's 10 years. But there are fees. There are fees associated with keeping your mark active periodically, right? So you can do it indefinitely. Your trademark never goes bad, but the patent does, right? But you're going to be paying those fees to make sure it stays alive. And so the USPTO keeps operating. But what I wrote down here doesn't make sense. It's either 5 or 10 years, and I can get that information to Lisa once I figure it out. Okay, let's go back to my presentation here. Okay, so those quotation marks that I put around Michigan Technological University was super intentional. That makes sure that the exact word combination, the exact phrase is being searched for. So here are some examples here. Overtime with a space between overtime. Will retrieve that exact phrase, but not overtime as one word. So if you're looking for computer software and put it in quotations, do not expect to find computer accounting software. You can do several searches like the one I did, right? Search several different fields at once using logical operators. Test does use some Boolean logic to limit and expand searches. So we've got and, or, and not. How many of you have used Boolean logic or had a library session? Okay, couple, several, great. If you don't remember it, that's totally fine. Just know that use and, you'll get both of the items that you're searching for, both words or phrases, or either not the first but not the second. And this is all in test help. I'll show you how to get to test help. There are a lot of logical operators. I'm just introducing you to a few, and they're on that handout, that double-sided handout with the table. Adjacent and same. Step forward. Truncation can get a little tricky. You'll have to use it a little sometimes in order to find it useful and have it not trip you up so much. So dollar signs and question marks can be used to expand your searches. Question mark will search any number of characters or than. I say question mark, I meant dollar sign. Not question mark, only one character or more. Right, so searching GAC, dollar sign rat, will retrieve a whole slew of different results. Our question mark P will retrieve certain results, but not those that have a space between the R and the P or not. And the asterisk. So make sure you only place this one to the left or right of a word or letter string, and only use it in the basic index or translation index. So it can be really useful, but in limited context. For those of you online, this table is linked in the guide, and I have provided it as a handout. Okay, so that is where test help is. I know that's really small. I'll show you how to get there. You have a practice slide here. Do you guys want to do the practice? Do you have any guesses? No, we're getting to the end of the session. Let's skip it. I do have the answers here. Let's get to our example search scenario. Okay. I'm going to switch here and go to tests to go through this scenario. So you're a beauty products business. And still, it's just going gangbusters. You're selling stuff left and right. So you invest in a new logo. Your designer shows you something that conveys peace and beauty, just like you wanted. It's a silhouette of a dove. You want to make sure that what this designer came to you with isn't infringing on any existing marks. Doesn't matter if you want to register it or not. Can you actually use it? Are you infringing on anybody else's? So we're going to look and see what design search code you could use, what international class you could use, and what description of mark using some keywords you could use to see if you're infringing. So let's go to text. Oh, okay. That's Pelt. It's right here. We'll open that in a new tab. The design search code manual is right here. There is a hyperlink in Test Health that is broken because the USPTO redesigned its site and didn't get all the hyperlinks. So if you are interested in looking at the design search code manual, find it here. Open that in. So trademarks can be categorized. If there is an image according to this big list of categories. Right, we've got, how many do we have? 29. Sorry for the scrolling for you, those of you attending remotely. And we're gonna look for dove. The best way to look for design code would be to just kind of start at the beginning of this table of categories. And we've got animals. Dove is an animal. We've got, oh, birds and bats here. Let's do that. When I get to this point, I just keyword search. Is there a dove? Oh, look, there's a dove. This is the design code for doves. Let's plug it into text. So many tabs, so little time. All right, we're doing a free-form search. Searching by code. We do not want the decimal point. We need to tell tests which field we're searching in. Right, so we have our code and we have our field. You always need to include a field so test knows where it's searching. There are 2,436 results. So safe to say we need to refine this search a little bit. How about some keywords? We have a silhouette of a dove. Maybe we can search using the keyword silhouette. And that we would search the description of the mark. You see here I'm using Boolean logic to connect these. I'm telling tests to search in the description of the mark, which is just how the person registering the mark decided to describe their mark in text. For the sake of time, I'll give you an extra one that we weren't looking for. Live. We don't really care about dead marks if we are worried about infringing on somebody, because the dead marks don't matter. So we're searching live dead, the word live. What else? International class. I'll show you how to do international class. There is our. All right, here's the help. Search field. International class. These are all of the fields that you can use to search the best database. Right now, we're interested in what international class or goods and services classification our product falls under. Our beauty products company. So cosmetics and cleaning products, probably pretty good bet. 003. Let's plug that in. Tell tests, we're searching international class. We'll submit it. Look what we find. So the beauty products company, Pelt soap. Anybody familiar with Dove? This look, yes, I see heads nodding, yeah. We should probably fire our designer because they're not very original. we're gonna get sued if we use this mark. Interestingly, there's also Dove chocolate. How does Dove that sells soap and Dove chocolate
Different parts.
exactly, right? So they're not infringing on each other because they're in different markets. There are some other fun things in the slide deck, another search activity to challenge yourself on. If you want some more information, you can definitely come talk to me. There's so much good stuff I could put in. But are there any questions with our last 6 minutes? Yeah,
Is it always black and white for the color of logo?
no, some of them do have color claims.
So I see that color is not clear as a feature of the mark.
Yes. So usually when color isn't claimed, it'll just be black and white. Oh, and let me show you, if you click this TSDR, this is how we find all of the awesome information about registering this trademark. So you can actually see all the documents. Let's look at the specimen that was submitted. Isn't that cool? I just think that's so cool. Right, you can see the drawing that was submitted. Right, I think it's super. More questions?
One question.
Yeah.
Why do we need a logo and when should we have a logo for a company?
So if you are interested in amping up your marketing strategy and you really want to associate your product with your company, that's where a logo will come to play.
So if you go to say the capital, register your company, must you have a logo also at the same time, or you will do it maybe a few years later? Or?
Yeah, you don't have to register a trademark. You don't have to have one, you don't have to register one, but if you want to, it can be a good strategy.
I see. So the registration of the company is for accounting purpose, for tax pay purpose, but this will be for marketing purpose.
Yeah.
Okay.
I've never had that question. That's awesome. Thank you. Anybody else?
If
Yeah.
you were to like update your logo, say, for example, Dove just wanted to change the stylization of it, would you have to file for a new trademark or could you make an amendment?
Oh gosh, I think you have to file for a new trademark. I think you can update your international class. But if it's different enough, like if they wanted to claim color, I think they would have to trademark a new logo.
I also have one more question.
Yeah.
It goes back to patents.
Right.
So say we're doing research here and we are involved with creating something new and we can get a patent for it. And we are the inventor. Does Tech own that patent as the assignee?
Yes. But you also don't have to pay any of the fees associated with getting that patent, which is awesome. None of the attorney's fees, correct, Jim?
Right, so if it's done within the scope of employment or with the use of substantive university resources like microscopy, shop, then the university owns it. The individual inventors are still the inventors, just like in a company setting. You don't have to pay for the patent, and the university would provide the inventors with a third of any revenue that's created from the patent.
So for the university, we cook that cost of that.
We license them to private industry.
So it's a share license between the inventor and the university.
Right, so someone creates an invention, we do a commercial assessment, we file a patent application, we issue a patent, we license the patent to a third party, and we give a third to the inventors, and actually we give a third to the inventor department, and we retain a third, and that's how we pay, that's how our patent works.
Until the money is recouped back, or how that
The royalties continue to come, and so we file patents when we think we can make our money. When we can make 3 times our money back, we only receive it.
So if does the inventor have say over it, or does Tech, because it's the assignee, have more say of like, can the inventor say like, hey, I don't want you to, this company to use this patent? Can Tech override that?
That's a great question. I don't know, Jim.
As a practical matter, yes, as a technical legal matter, no. Michigan Tech could do whatever it chose to do. There's certain circumstances where it'd be exposed to lawsuit, depending on all we did, but as a practical matter, patents. So if I'm gonna be successful in commercializing this patent, you're gonna be involved. And if you're not happy, then nobody's successful. So you don't have a legal right to tell me what to do,
Okay.
but you have control because I can't take that patent and sell it to somebody without you at the table. Because no patent has value in and of itself.
Okay.
So there's kind of a practical answer to that. It's not really, the legal answer is I can do whatever I want. But I would be foolish to do whatever I want because I would never be successful.
Okay.
Good juicy question. I really like it. Okay, before everyone else skedaddles, we have a great trademark resources slide here that lists a bunch of cool stuff that you can investigate if you're interested in trademarks. Anything else that you have questions for me about, personal work email is there, or the generic library email, that'll all get rerouted to me. And the URL for the guide that I have for them. Awesome. Thanks, Annalise. Thanks, Jen.